and welcome to the Design Patents webinar. My name is Bailey Reeves, and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the bottom of your screen, and our technical assistance team will help in any way possible. If you are having issues hearing over the phone, you may press *0 and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in a listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located on the lower right side of your screen. Type your question into the text field and hit send. Please keep the send to default as all panelists. This seminar is accredited for 1.0 hours of Illinois' MCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be emailing evaluation forms at the end of the webinar and will ask for the codes. If you are attending today but did RSVP with your email address, please contact jflynn@brinksgelson.com to receive the evaluation forms. If you have any questions regarding CLE, please contact cle@brinksgelson.com. Today's webinar was prepared by Craig Bushman and Alan Elliott Rhodes and will be presented by Linda Nadler and Craig Bushman. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce your first presenter for today, Craig Bushman. Craig, you now have the floor.
Thank you, and welcome everyone who's listening. Good morning, good afternoon, depending on where you are in the country. Just briefly, I'll be giving the first half of this presentation. I'll be discussing a comparative review of different licensing strategies and what we can learn from the approaches of these manufacturers, specifically Tesla, Toyota, and Ford, and considerations that you might take into account if you're developing your own licensing program. Briefly, just some background about myself. I have a mechanical engineering degree. I went to the University of Michigan, and I've worked in a wide variety of technologies, automotive, the oil and gas industry. I actually worked as a field engineer in the Gulf of Mexico and internationally on oil rigs for several years, and aerospace, semiconductor manufacturing, medical devices, and the like. So as Bailey mentioned, we do have CLE credit for this course, and the first CLE code is COIL, C-O-I-L. So if you please write that down, we will need that information when you submit your forms. So the first CLE code is COIL. And so a brief overview of what I will be discussing today is what is a patent pool, for those who aren't particularly familiar with that particular topic. And then I'll look at each of Tesla, Toyota, and Ford's technology, because their technology has an effect on the different licensing schemes and the specific strategies chosen by each of the manufacturers. We'll have a brief Q&A at the end if there are any questions. So a patent pool is a collection of patents, and the patents may be from a single company or they may be from a multiple or several companies, and they collect them into usually some sort of a holding company that will then either license them out or somehow handle those intellectual property rights and the patents. And so there are a few ways to do this, or why you would form a patent pool. One is a defensive strategy. Perhaps there is a fragmented IP market, and one of the most common ones, at least in the past, have been in the areas of semiconductor technology. It was almost in the old westerns, there was the standoff where everybody had their different arms pointed at each other, and this semiconductor pool would be sort of similar. Every company had their own patents, and it was very likely that one company might infringe on other companies, and rather than having the standoff, it's a very fragmented market. the parties got together and say, hey, let's license this technology to each other, rather than getting into prolonged litigation that would just drain resources. So it might be fragmented. There might be blocking patents. Say two parties might have a patent that would each prevent the other from selling or marketing their own technology. So rather than preventing each competitor from offering their products for sale, there might be an agreement to say, let's work out some sort of an agreement to address the issue of blocking patents. There could be a reason for network effects or technology standards. For those unfamiliar, network effects are such that the technology actually becomes more valuable the more people that use that technology. So consider if you're the first person ever to have a cell phone, you know, there certainly is some value to that. You can still call landlines and other places. But your cell phone certainly becomes significantly more valuable as more people in turn also get cell phones. And so that's sort of the network. As the network and number of users of cell phones grow, there is a value, increased value to that technology. And so if there's a way to either enhance that network effect or lower the barriers for potentially competitors so that if you can't fill the entire space market for that network, well then you might actually still make more money by licensing your technology to competitors who can then encourage consumers to adopt the technology in that network, and therefore sort of growing the pie for everybody. And that sort of, you know, points to the last point there, the increase in supply and demand. So there is one concern, or a concern, is the antitrust. Of course, some of you may be familiar. The antitrust, you can't suppress competition. So any agreement has to be shown, or has to at least done the due diligence to show that it's not going to suppress competition. It will, in fact, enhance competition. And it can't be done to control an industry. You can't divide up on markets and so forth. So that is of some concern, but if you do your due diligence ahead of time, those are all things that can be addressed. So turning now to Tesla, and there's their fleet of cars. They got the Model S, the Model X, and the newly announced Model 3 there on the right. And so why do we care about Tesla? So it's the first significant new U.S.-based auto manufacturer since Chrysler nearly a century ago. And the Model 3 launched earlier this year. It was disclosed at a large press event at the end of March, and the first pictures were disclosed. It's projected to go into manufacturing at the tail end of 2017, assuming there aren't any delays, which is always an important caveat when considering Tesla, since the first two vehicles were significantly delayed. But that's the target. The Model 3 is the fastest launch of any automobile anywhere, and one of the fastest consumer product launches anywhere. So within the first few weeks, in the first 2 days, they had over 232,000 orders placed. And those orders required a $1,000 refundable deposit. So this is actually people putting their money down. And right now, there are approximately just under 400,000 confirmed orders for the Model 3. So you can kind of see in this chart, for automotives, you have to go back to 1955, the Citroen DS, which had 80,000 orders in 10 days. There's the Model 3, and the original iPhone had about not quite 25% more orders in 2 days, but it's a significant consumer product launch. And since I'm sure everybody's wondering, I certainly did, what exactly does a Citroen DS look like? There's an example of one from 1955. So you can see we've come quite a ways since then. So Tesla's goal is not just to sell cars. Their goal is to develop a new market of purely electric vehicles, and not hybrids, not internal combustion engines. It's an entirely new market, essentially. And so for Tesla, this is its existential challenge. If you're developing a purely electric automotive market, you have to displace, you're a complete substitute. You're not a complementary product to an internal combustion engine. And so you have to not only produce these vehicles, you have to change a whole culture that's developed around internal combustion engines that's been around for over a century. And so not only that, you have to create the network of charging stations. Without a network, a lot of people feel that there isn't terrible value to having an electric car. And each of these kind of have a feedback effect between them. As you change the culture, there's more demand for an electric charging network. As the electric charging network increases, you help change the culture as people realize, hey, this actually is a feasible thing. And so as a whole, as both of these change, people rationalize and can justify purchasing an electric vehicle market. So it's a big challenge. It's not just simply selling an internal combustion car here like other manufacturers. So part of what Tesla has done is they have announced that they are going to have an open patent strategy. They're not going to charge licensing fees. And so Tesla announced this in the summer of 2014, and Elon Musk announced, all our patents belong to you. And so for those of you who are not millennials or Gen Xers, that's a reference to a late 80s, early 90s Japanese video game called Zero Wing. And it was a poorly translated phrase from Japanese. It said, all our bases belong to you. All your bases belong to us is the actual phrase. And so it's sort of an internet meme now that a lot of people are familiar with. And that's what Elon Musk was referring to, and that's what the image there is, sort of a caption from the video game with Musk's phrase on that. So they announced this open licensing strategy or open source strategy, and their promise was, quote, to not initiate patent lawsuits against anyone who, in good faith, wants to use our technology. So obviously there are a lot of caveats to that. You might, if you're interested in using Tesla's technology, you probably still want to get in touch with them and confirm that you're not going to step on any toes. What does good faith mean? You do have a sort of a reliance defense, but it's a limited open source patent pool for the Tesla's technology as of the date of the announcement. So it's not going forward technology, it's technology as of 2014, the summer of 2014. And so within this pool, there are vehicle components, battery charging, energy storage, and power optimization technologies. They cover those 4 different areas, or could be grouped into those areas. And so Tesla has done this, as I mentioned at sort of the prelude to this, is they've got this challenge with the culture and the network effects. And here they want to encourage other companies to adopt Tesla's technology in the ecosystem. This will reduce barriers to entry and the capital cost to entry for competitors. And again, this goes to why would anybody do this? You know, Tesla is giving away their crown jewel IP technology. The reality is even with selling 400,000 cars in the Model 3, that's just a drop in the bucket in a U.S. automotive market that's close to 17 million vehicles per year. So Tesla is never going to fill a large portion of that market, or at least not anytime in the immediate future of the next decade probably. So it's going to have an easier time if others can move into this market to help Tesla change the culture increase the network of charging stations and increase consumer demand and awareness for purely electric vehicles. And so this is where, and this graphic just shows the projected increase in charging stations. The red ones are Tesla-specific ones, and the growth is of other manufacturers and other producers of charging stations. And so lowering these cost of barriers will help Tesla sort of increase the pie of electric vehicle users, purely electric vehicle users, which in turn will help Tesla. And that's sort of what this slide discusses: accelerate change in the away from an internal combustion engine-centric culture, and increase the size of the electric vehicle market. And in turn, also sort of set a standard of sorts. So everybody is using perhaps the same charging infrastructure rather than getting stuck with each manufacturer perhaps using a beta versus VCR, VHS standard, or Blu-ray versus HD DVD sort of issue. And so this isn't actually, I mean, certainly it works well for Tesla, but it's not the first time any company has done this. This is a lot of historical precedents for major new technologies, particularly those that have a network effect. Textiles, a lot of the textile technology in the early 1800s and 1700s in the New England region was a cooperative. Bessemer steel production was shared amongst the various steel manufacturers, personal computers, wireless communication for setting various standards, and so forth. So this approach has a historical precedence. And so you can see here, this is the rise of the projected rise of all electric vehicles, and you can see Tesla's projected annual sales and then cumulative sales of all electric vehicles, or all vehicle sales in terms of the global standard of, or a global metric of almost 500 million cars a year by 2040. So it's a significant market, and it's going to grow from almost nothing in 2020 to nearly a third of the market by 2040. So as a comparison, it's helpful to see what other companies are doing to understand, why did they choose a different approach. And so here is the Toyota Mirai, which is a hydrogen fuel cell vehicle technology. And this has been, certainly Toyota's very famous for their hybrids, the Prius, of course. But long term, Toyota has emphasized their fuel cell technology as an alternative to internal combustion engines. So some of the differences, with Tesla, is Toyota is a mature, large company. It's the largest automotive manufacturer in the world, and it doesn't have the same existential problems that Tesla does. I mean, it's selling millions of cars each year, and that size insulates Toyota from some of the concerns of Tesla. Toyota can create markets and explore multiple strategies because of its size. And an example is it single-handedly created the hybrid electric vehicle market, the Prius and the like, starting back almost 20 years ago. The first Prius came out in the late 90s. Nonetheless, Toyota was the second after Tesla to announce some sort of alternative fuel technology patent pool. And as I mentioned, this is for its fuel cell technology, and their new model, Mirai, which has just been released to public sales in California within the last 6 months. So very limited sales have begun on that, and certainly Toyota hopes to grow that market. And for those unfamiliar, hydrogen fuel stack is just a chemical reaction that combines hydrogen with oxygen, and all you're left with is water as the waste product. And so, but Toyota, unlike Tesla, which had a large pool where everything was available, Toyota is divided into two separate patent pools. First is powertrain technology. This relates to fuel cells, hydrogen tanks, control systems. And for this technology, it's royalty-free through 2020, so a very short period of time. On the other hand, it has a second pool for hydrogen production and supply. And this relates to manufacturing production, storage, how do you dispense the hydrogen safely into a vehicle, at a fueling station, and presently there is no expiration for this royalty-free access. So the question is, why would Toyota set up two different pools? And so Toyota hasn't said anything, but we can speculate about some of the reasons. And so for the powertrain technology, perhaps it's Toyota hopes to create a fuel cell vehicle standard, somewhat similar to Toyota or Tesla's electric vehicle strategy. But Toyota, as I mentioned, because of its size, it's less reliant on others to establish the market. Toyota has the size and the capacity. It could fill probably, and it likely will for at least several years, the entire fuel cell vehicle market on its own. So it may wish to, like I said, set a standard, help create awareness for that technology, but it doesn't need or is not reliant on others to fill the space. But with its hydrogen production and supply, there are network effects here. If someone owns a hydrogen fuel cell vehicle, they still want to be able to drive and know that there's going to be a hydrogen fueling station somewhere on their trip. And so there's that network of fueling stations, and that network creates an incentive for Toyota to let others help develop that network. Networks are large. You've got a nationwide footprint potentially to fill with fuel cell networks. Obviously, that would cost a lot in capital and time to do that. So Toyota is looking to the market to help it establish this network of fueling stations. And so this would be similar to Tesla's strategy related to the battery charging and storage, in having that network established. And finally, we've got the Ford Motor Company, and that's the C-Max. It's an entirely hybrid electric vehicle, and it can be plug-in. It's a plug-in version of the hybrid electric technology that Ford has preferred. It too, like Toyota, is a very large, mature company. It doesn't face the existential concerns that Tesla does. And they were the third after Tesla and Toyota to announce their own patent pool. Ford, at least at the moment, has not gone into the same alternative fuel technologies like Tesla and Toyota. They're focused primarily on what we would call, quote unquote, the traditional hybrid electric vehicles, the Prius style that combine a small internal combustion engine with a battery pack that either is charged by the gasoline engine or in some cases can be separately charged via an electrical outlet. Ford hasn't described the entirety of its patent pool, but their press releases suggest that it's primarily focused on the hybrid electric vehicles, that's the gasoline and battery powered, and partially electrified. And that just is a hybrid electric vehicle, as I mentioned, that is capable of being plugged in to charge the batteries. This technology is nearly 20 years old. As I mentioned, Toyota had established this market with the Prius starting in the late 90s. And this is a very traditional licensing model where Ford is charging a fee to use their technology. So why would they charge a fee? And well, Ford isn't attempting to start or establish a new market. They're not attempting to establish a fuel cell market that doesn't exist. They're not attempting to establish a purely electrified vehicle market that really doesn't exist. It's an established market. There is certainly advances to be had, but it's a mature market. People are well aware of this. So this Ford probably considers this the different incentives. There's no network. It's a proven technology. And so in the end, this is really potentially a source of revenue for Ford. So it's a very traditional licensing model. So what conclusions can we draw from these different licensing approaches that these companies have used? Well, each company has a different perception of the market and the technology. Is it a new market? Is it established? Is it a market and technology that could benefit from some sort of network effect? Is the value of the technology, does it grow as more people adopt that technology? Are there cultural norms established? Are people familiar with internal combustion engines versus electric vehicles in which people may have range anxiety, whether that's justified or not, for example? So is there these established norms that need to be changed? And finally, what are the relative strengths of the companies? What are their cash positions? Are they the market leader? Are they big enough and strong enough to establish a market by themselves? So these are all factors to take into account if you're considering a licensing scheme for your technology. And here's the link that you can write down. I'm not sure if you can click directly through the slides to it, to a Law 360 article that I wrote and was published earlier this year on this specific topic. And so that concludes my portion. If there are any questions, please let me know. I'll give you a moment. And in the interim, while you're collecting your thoughts, the second CLE code is chemicals. So you would like to write that down, chemicals, for your evaluation form. And if there are no questions, there is one question. I've given this presentation once before. Someone made an interesting observation and asked a question. About a decade ago, Mercedes made the announcement that they were going and also prepared and aired a significant number of commercials on TV that they were offering their safety technology to their competitors for free, their patented safety technology without a license or without any royalties. And the point of the ad was, we're Mercedes, we think all life is important. Here is our IP, and other competitors can use it without any sort of licensing because we're stand-up people. And the question was, well, why would Mercedes do this? And it's a good question, and I don't have a good answer. It's certainly possible that Mercedes is just really stand-up people and they're charitable people. More likely with a profit motive involved. And since there, how much of does safety technology, is that a significant factor for a lot of people when they're buying a new car? And it may be, or it may not be. And if it's not, there may not be quite the incentives to keep a proprietary hold on your safety technology. One other possibility, and what I suspect may be the reason, but I don't know, is that it could be that certain of these safety patents were getting close to expiring or getting long, and perhaps Mercedes was changing their technology. This was just a good PR move for patents that they decided they were probably not going to continue paying annuities and maintenance fees on. But that's just something, a question that one person asked. And if there aren't any other questions, I will hand over the presentation to Linda Natler, who will discuss specification and claim drafting to avoid indefiniteness. Linda, over to you.
Hi, good afternoon, everybody. This is Linda Natler. I'm sorry Alan couldn't make it today, so I'm covering as best I can. And while Alan did all the work on this, I'm familiar enough with the topic that I hope you learn enough for your satisfaction. So what we're talking about today is we talk about definiteness in patent claims. First of all, what was the standard before the Supreme Court Nautilus decision? What is the standard now? And after 2 years since Nautilus, what was the effect on decisions? And because we are talking mostly to our chemical practice group, the decisions that I'm going to discuss are more from the chemical pharmaceutical field for your interest. So first of all, we start off with the statutory language of Section 112 of the Patent Act, before the AIA and post-AIA. So before the AIA, it said the specification shall conclude with one or more claims, particularly pointing out and distinctly claiming the subject matter which the applicant regards as his invention. Now, in the post-AIA, the word applicant and his invention was changed to inventor or a joint inventor regards as the invention, because as we know, post-AIA, a company can also be the applicant. So this only clarifies that this is about the inventor. Other than that, the wording hasn't changed. Now, the indefiniteness standard up to 2014, when the Nautilus decision came out, was based on the Federal Circuit, saying that the claim passes the indefiniteness or the definiteness threshold, I have to say, so long as the claim is amenable to construction and the claim as construed is not insolubly ambiguous. So that means insolubly ambiguous means that the person of ordinary skill would see that the meaning of the claims is discernible and it is definite even though the task may be formidable, and even, now here it comes, if the conclusion may be one over which reasonable persons will disagree. And and that was very broad. Also, later on in the Dow v. Nova decision, the Federal Circuit also quoted that the claim was not indefinite if someone skilled in the art could arrive at a method and practice the method. So it is more like if somebody was able to figure it out. But, so we have here the timeline. So there was the first, the history before the Federal Circuit with Nautilus. Then the Supreme Court came out with a Nautilus decision. And then the post-Nautilus standard then was applied to these three cases that are listed on the timeline. So there was one Teva Pharma v. Sandoz. Then there is Dow Chemical v. Nova Chemicals, and then there is AkzoNobel Coatings v. Dow Chemical. As you see, Dow Chemical is party to two of these lawsuits, and as we will see, Dow wasn't that successful in their endeavors. So first we talk about the Nautilus decision itself. So this is a heart rate monitor used with exercise equipment, and the whole concept was to remove noise, so to remove disturbances that were generated by things other than a user's heartbeat. And the claim itself says that it has a heart rate monitor for use by a user in association with exercise apparatus or exercise procedures comprising an elongate member with a display device, an electronic circuitry, and on each half of the elongate member, a live electrode and a common electrode, and mounted in spaced relationship with each other. So the Nautilus said that was indefinite because what is the spaced relationship? So, and as we say here, the Supreme Court says that it is necessary for definiteness that a patent must be precise enough to afford clear notice. So clear notice, and it must be apprising the public of what is still open to them. So really the metes and bounds of a claim must be clear. And it further says that to tolerate imprecision just short of that rendering a claim insolubly ambiguous would diminish the definiteness requirements public notice function. So it cannot be that reasonable people may disagree. So and the Supreme Court then says that this would foster the innovation discouraging zone of uncertainty. And so by criticizing the Federal Circuit, the Supreme Court says that's not sufficient. So the ambiguity cannot be tolerated. So the patent is invalid for indefiniteness if its claims, read in light of the specification delineating the patent and the prosecution history, fail to inform with reasonable certainty those skilled in the art about the scope of the invention. So here we have the reasonable certainty, and not reasonable people may disagree. What the Supreme Court points out here is, well, the claim itself does not have to explain every term in it, but it's important that the specification and the prosecution history lay out this reasonable certainty about what the claim actually means. So then the Supreme Court sent the whole case back to the Federal Circuit to determine the definiteness of the claims based on this new guideline. And the Federal Circuit then applied this new standard and still decided that the claims were definite based on intrinsic evidence. So they looked at the specification and said, you know, really the spaced relationship is explained well enough and the claims are definite. So then in the follow-up time, so about a year later, the Teva decision came out. This one related to a drug used to treat the symptoms of relapsing forms of multiple sclerosis. And there was one thing where the claims talked about molecular weight. And it was known that there were 3 different measures for molecular weight that were known and customary, but each of them would come to a different result. So one was the peak average molecular weight, MP. The second was the number average molecular weight, MN. And the third one was the weight average molecular weight. Now, as the Supreme Court said, you have to look at the intrinsic evidence, which is the specification. Well, the claims did not say what measure was supposed to be used, and so they looked at the specification. The specification also didn't state what measure to use. Then, to complicate things, there were related patent applications based on the same specification, and during the prosecution, the person who prosecuted these applications applied a different molecular weight in the prosecutions of two different applications. So even the prosecution history contradicted itself. Now, there is extrinsic evidence, which is, for example, an expert here that was used, and the expert can state what the person of ordinary skill would understand, but the expert cannot add anything to the disclosure. The expert can only explain what the terms in the disclosure mean. And so in this case, that was not helpful, and the Federal Circuit determined that the claims were indefinite because they failed to inform the person skilled in the art with reasonable certainty as to what measure to apply. So the claim scope was not clear. Now that was a bummer. Then the next case that came out 2 months later, Dow Chemical had a patent and sued Nova for infringement. And so the lower court, so the jury, found that Nova infringed the claim and that the patents were not invalid for indefiniteness because they used the pre-Nautilus standard, because the lower court decision was pre-Nautilus. And then that was in 2010. Then in 2012, the Federal Circuit affirmed, but remanded to the district court on damages, and the district court granted supplemental damages, and that again was appealed to the Federal Circuit, and that was then post-Nautilus. So then, so here again, sorry, I'm not a chemist, I'm a physicist, so I can only read this to you, and I don't have a clue what this means. The technology related to ethylene polymer compositions having improved modulus, yield strength, impact strength, and tear strength. So, and the indefinite, so the allegedly indefinite term was the slope of strain hardening. So then Dow had an expert saying that one of ordinary skill in the art would know that the slope of the hardening curve would have to be measured at its maximum value, which reflects the best tensile performance of the material. So, but again, there were the maximum slope. There were several different methods to measure them. 3 were known, and then the expert made up a new one. And so that's where it gets critical. So the expert added something to the disclosure. The intrinsic record itself did not discuss any of the methods, the 3 known ones plus the one that the expert set up. And the prosecution history likewise did not provide any guidance as to what methods to apply. And the Dow expert did not testify that the person of ordinary skill would choose the method he used. And so there, on top of that, I'm not even sure that that would have been sufficient, because the expert can interpret the intrinsic record but cannot make up anything new. So then the question was whether the existence of multiple methods leading to different results without guidance in the patent would render the claims indefinite. Before Nautilus, it was, well, if a person of ordinary skill could figure it out somehow, and then that was definite. But after Nautilus, remember, it was about giving notice to the public, and then that means this the prosecution history and the intrinsic record fail to inform those skilled in the art with reasonable certainty about the scope of the invention. And thus, the patent was held to be indefinite. You know, haven't the damages gone back on remand and appealed again? That would still have a patent. Well, and now we have the last case where this is an extrusion process for a low viscosity aqueous polymer solution. So this was an appeal by AXO that where the lower court had decided that the claims were not infringed, and it was a cross appeal by Dow regarding the decision that the claims were definite. So, and these slides deal with the cross appeal regarding the definiteness. So, so Dow had two phrases that were alleged to be indefinite. One was in Claim 1, the viscosity below 10 pascals for failure to recite an accompanying temperature. And in Claim 2, it said carried out at a temperature from 5 to 150 degrees centigrade above the melting point of the polymer for failure to specify to which steps the limitation applies. So there were various steps, and not all of the steps had to be performed at this elevated temperature. So then there was an expert testimony from the AXO expert that said the person of ordinary skill would understand that room temperature is implied where no temperature is mentioned. And the intrinsic record, so the prosecution history, supported the expert testimony. So the expert didn't make up something, but only pointed out here that is how it would be interpreted, and the intrinsic record actually confirmed that. So the room temperature was only mentioned in connection with the viscosity measurement and not with the other steps. So the temperature limitation, accordingly, was supported by the specification because that one applied to all those steps where an elevated temperature was mentioned. And the court accordingly said the claims were definite because the specification was explained enough that a person of ordinary skill, of course, would have the clarity needed. So, and as a result, of course, we can learn from this, not only in claim drafting, but also in writing specifications and considering prosecution history. So if there is a claim term that could have more than one meaning, you would have to provide guidance in the specification what standards to apply. I mean, you don't need to say it must be applied under this standard, but you would certainly say which values apply to which standard. So if there are several methods, you know, you can give ranges for one method, you can give ranges for another method, but you have to be clear what method you want to use. Then if you are prosecuting your application, so and sometimes you work with an application that you didn't even write, then you can get the help from an expert who, based on the specifications that you have, could make a statement that the person of ordinary skill would know what it means. And certainly that there is, for example, that there would not be any reasonable disagreement on what it means. So in order to provide clarity, of course, the ideal case is that you consider that during the drafting stages. Now, in an infringement action, it's the same. Of course, it depends on what side you're on. And if it's your patent that is attacked, then you want to have an expert state that the person of ordinary skill would know which methods to use. And make sure that it's based on the intrinsic record and that you don't need to make up stuff. So on the other hand, if you're attacking a patent, then you just have to point out the gaps in the intrinsic record and say, yeah, but that's really not supported by the intrinsic record. And that was it. For now, we have the third CLE code now. Please write down the word triangle. Triangle, if you need CLE. And thank you very much. I hope this was not too bad. I was covering for Alan. And if you have any questions, I'm certainly still able to answer them. I don't see any questions. So, well then at this point I only want to emphasize how important it is to write a complete explanatory specification to disclose all details. And well, even though all these cases were about indefiniteness, supplying the standards and methods you use is also important for the enablement standard. So, the 112, sometimes it goes one way or the other, indefiniteness, written description, or enablement. Those are all things that can't be cured after the fact. So it's very important that you consider these things at the drafting stages. Thank you very much.